Okay, continuation. What do you understand by the doctrine of piercing the veil of corporate entity? What is this doctrine? Okay. The doctrine that a corporation is a legal entity distinct from the persons composing it. It is a theory introduced for the purpose of convenience and to serve the ends of justice. But, okay, remember this one. When the veil, pag ginamit yung veil ng corporate fiction as a shield to perpetuate fraud, to defeat public convenience, to justify wrong or defend crime, this fiction shall be disregarded. Okay? And the individuals composing it will be treated identically. Ibig sabihin, korporasyon ang liable sa lahat. Pero, if the actions of this corporation is a means to shield or perpetuate fraud and the like, okay, this veil will be torn. This veil, okay, veil will be torn and destroyed to make the individuals liable. Okay? Because this corporate veil cannot be used to shield blatant violations or prohibitions under the law. Next. So what are the elements? That must be present to justify the piercing of the veil of corporate fiction on the ground that the corporation is a mere art alter ego? This is the so-called three-prong test. Okay, the first one is the control test, followed by the fraud test, and lastly is the injury test. Okay, when we say control test, okay, here the control is not mere stock control but a complete domination, okay, not only of the finances, the policy, okay, but also the business practice of the corporation. So in here, the corporate entity, okay, as to the transaction, had at the time no separate mind, will, or existence of its own. And another prong test is the fraud test. When we say fraud test, okay, here the control must have been used by the defendant to commit a fraud or a wrong, and this fraud was used to perpetuate the violation of statutory or legal breach. And lastly, the control and the fraud must result into a injury. Okay, here this is the last prong test. Okay, the injury test. And here the injury, there must be an injury or unjust loss complained of. Okay, we also have different theories under the corporation code, and some of them is the concession theory. The concession theory is under the attribute that it is created by operation of law. Under this theory or principle, okay, concession theory or principle is one where the creation of a corporation, under which a corporation is an artificial creature without any existence until it has received its imprimatur of the state, acting according to law through the Securities and Exchange Commission. So how are constitution created? How is a corporation created? Okay, so a corporation can be created by a general law or a special law. Okay, the general law, okay, here the private corporations are generally created under the provisions of the corporation code. So that is the general law. Okay, so this is done by filing the appropriate articles of incorporation with the Securities and Exchange Commission. And the life of the corporation starts from the issuance of the certificate of incorporation. How about those created under special law? Okay, the special law or those that are public corporations, okay, are created under special laws. Private corporations cannot be created by special law. Why? Because they are governed by the Corporation Code. And the Corporation Code is the so-called or what we consider as the general law. So, however, there are certain exceptions. Okay? Those government-owned or controlled corporations are the so-called GOCC, which are actually private corporations. Okay? So, next is the right of succession. So here, the capacity to have continuity of existence despite the changes on the persons who composes it or who compose it. Meaning, ang korporasyon ay pwede pong ituloy-tuloy yung kanyang existence kahit na papalit-palit pa yung mga taong nagko-compose sa corporation. Sino tong mga taong to? Yung mga directors, stockholders, officers, kahit pa nagpapalit-palit, namatay na sila, or umalis na sila, nag-ibang bansa, nagpalit ng korporasyon. Okay? Here, the corporation has the right of succession. Meaning, it can continue its existence kahit na there are changes in the persons composing it. Next is the powers, attributes, and properties of a corporation. Okay, we have the so-called limited capacity doctrine. This limited capacity doctrine is also known as the theory of special capacities. Okay, under this theory or doctrine, okay, no corporation under the Corporation Code shall possess or exercise any corporate powers except those conferred by law, articles of its articles of incorporation, those implied from express powers, and those that are necessary or incidental to its existence. So the corporation's capacity is limited to such express, implied, and incidental powers. So, remember, if yung act ng corporation is not one of those express, implied, or incidental, that act is considered as ultra vires acts. Okay? Next is we go to the different classifications and distinctions of a corporation. The first one is public versus private corporation. Okay? As to organizers. In a public or corporation, the organizers are or is the state. Okay? While in a private corporation, the organizer is a private person alone. Okay, or with the state. As to functions, okay, in a public corporation, the government of a corporation of the state, okay, and the private corporation is usually for profiting functions. Okay, as to legal status, we have the de jure versus de facto corporation. Okay, what is this de jure? Okay, a de jure corporation is a corporation organized in accordance with the requirements of law. While a de facto corporation, okay, a corporation where there exists a flaw. Okay, may mali dun sa korporasyon. Okay, the following are the requisites in order, okay, to consider a corporation de facto. Number one, there must be a valid law under which it may be incorporated. Number two, there is an attempt in good faith to incorporate. And lastly, there is a use of corporate powers. So, paano natin malalaman na de facto corporation ito, ma'am? Okay? Here, the issuance of a certificate of incorporation by the Securities and Exchange Commission is a minimum requirement of continued good faith. Ang ibig sabihin lang nito, dapat yung corporation, yung mga requirements under the law, they should have at least tried to submit it before the Securities and Exchange Commission. If there is a substantial compliance, kung na-comply nila lahat yung requirement, that is the so-called de jure corporation. However, kung merong pagkukulang or pagkakamali or the so-called colorable compliance, then that is a de facto corporation. Question, can you attack a corporation's existence collaterally? Okay, the answer there is no. Because you can only attack it directly by the state in a quo warranto proceeding through the Solicitor General. You have also the so-called corporation by estoppel. Ano to? Okay? It is a group of persons which holds itself out as a corporation and enters into contract with third persons on the strength of such appearance cannot be permitted to deny its existence in an action under said contract. Okay? Corporation by estoppel. From the word estoppel, you are estopped from questioning the liability. Kasi nga, okay, always remember, a corporation by estoppel is not a real corporation. Hindi ito tunay na korporasyon. And those who assume to act as a corporation, yung mga nag-a-act, yung mga taong gumagawa ng actions on behalf of that corporation at alam nila na wala silang proper authority, they are liable as what? As general partners. So meaning, being a general partner, they will be liable up to their personal properties. So, those who were not aware of the defect, paano naman yung mga nag-act, okay, for the corporation, pero hindi nila alam na may nawalang authority yung korporasyon. Okay? Kung hindi nila alam or if they are innocent, okay, acting in good faith, they are only liable up to their investment. Pero kung alam nila na wala silang authority under the law, they are liable up to their personal properties. Next, we have the so-called corporation by prescription. Ano naman ito? This corporation by prescription is a corporation that was not formally organized but has duly recognized by immemorial usage as a corporation. Okay, with rights and duties maintainable at law. Example is our Roman Catholic Church. Under the law, mababasa nyo, there are only two expressly identified and classified kind of corporation. The so-called stock and non-stock corporation. Okay? Ano ang stock corporation? Ang stock corporation is a corporation in which capital stock is divided into shares. Capital. Tanda nyo to ha. Yung capital na stock ay nahati-hati. It is divided into shares and is authorized to distribute to holders of such shares. Ang ibig sabihin nito, may isang buong kapital. At itong kapital na to ay hinati-hati. It is divided into shares. And these shares are authorized. Ibig sabihin, pwedeng i-distribute, pwedeng ibenta sa mga holders ng korporasyon. Okay? Always remember, the Supreme Court ruled that even if there is a statement of capital stock, the corporation is not a stock corporation if dividends are not supposed to be declared. Okay? That is though distribution or retained earning. Ang ibig sabihin nito, kung, okay, tandaan niyo, kahit may nakalagay na stock capital or capital stock, pero hindi ito divided into shares at hindi ito na-declare, hindi ito distributed, bawal i-distribute, this is not a capital or this is not a stock corporation but merely a non-stock corporation. Okay? How about a non-stock corporation? What is a non-stock corporation? A non-stock corporation is a corporation which does not issue stocks. Wala pong stocks. Okay? It does not distribute dividends to their members. In the governing body in a stock corporation is the so-called board of directors. Sa non-stock corporation, ang governing body natin ay board of trustees. At ang tawag natin sa mga taong may hawak ng shares sa isang stock corporation are stockholders or shareholders. Sa non-stock naman, ang tawag natin ay members. Okay? We have also the so-called domestic versus foreign corporation. Of course, from the word domestic, if it is organized, if it is formed, organized, and or existing under the Philippine laws, that is a domestic corporation. But if not, it's a foreign corporation. We also have those other corporations. Example, other corporations, closed corporation, special corporation, educational corporation, okay, the corporation sold and the religious corporation. Okay?